The legal battle between the state and former Housing and Infrastructure Minister Ronald Chitotela over a disputed settlement agreement on Mr. Chitotela's old case involving acquisition of properties reasonably suspected to be proceeds of crime is still active before the Economic and Financial Crimes Court, pending hearing of an appeal by the Anti-Corruption Commission. In the latest submission, the Commission claims that the former minister was never tried by any court after being arrested on the said charges. According to the Commission, there is no evidence of Mr. Chitotela having taken his plea to the charges against him, leading to his discharge. The Commission says a plea of outre fois does not lie where there has been no determination of the merits, adding that to sustain such a plea, the defendant has to show that on a former occasion there has been a verdict delivered by a jury to the court. It is a submission of the Commission that an undertaking that was made pursuant to Section 80 of the SEC Act does not give rise to a plea in bar on the basis that no plea was taken and trial never took place. The Commission says the charges that were levelled against Mr. Chitotela that resulted into the undertaking were not determined on their merits as required by law for there to be outre fois acquit or outre fois convict. In this matter, the Anti-Corruption Commission filed an application before court to set aside an out-of-court order settlement agreement granted by the Commission under the previous management to have his charges dropped. The Commission alleges that Mr. Chitotela made a false disclosure of his properties by surrendering his wife's property instead of his to have his corruption charges dropped, among other allegations. But in his response, Mr. Chitotela says, contrary to the claims of the Commission, he gave an honest and full disclosure of the properties, with the Anti-Corruption Commission making an undertaking not to institute criminal proceedings against him. Darius Jr., Damo News.